Calling to order the Sunshine Ordinance Task Force. This is the Compliance and Amendments Committee meeting on November 26th. Let's call roll, please.
Item number 1, call to order, roll call and agenda changes. Bruce Wolf.
Nope.
No.
Present.
Present. Yeah. Fiona Hinsey.
Present.
Fiona Hinsey present. Chair LaHood.
Present.
Chair LaHood present. We have a quorum, and we are starting at 4:34. Agenda changes. I just wish to put on the record that for item number 4, file number... Hang on a second. Item number 4, file number 19080, complaint filed by Paul Vanderwert. Mr. Vanderwert called me at 2:15 today to say that he would not be able to make an appearance, and I let the respondent know that that's what he said. The respondent is here.
Okay, so committee members, what would we like to do here?
Well, we got to do item number 2.
Oh.
Well, that first. That's just the
excuse me,
agenda
that's
change.
agenda change. Okay.
Yeah.
So let's have item number 2, please.
Item number 2, approval of the September 24, 2019 Compliance and Amendments Committee meeting minutes.
I'll move the minutes together.
Second.
Okay. Let's take it by acclamation.
Okay.
You need public comment.
Public comment on the minutes? Okay, let's take it by acclamation.
Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction but not on today's agenda.
Do we have any members of the public who would like to comment? Seeing no members of the public.
Hello?
Oh,
Hello?
yes.
Yes? Can you hear us?
All right. Yes.
Okay.
Good evening. Good evening, Compliance and Amendment Committee. Anonymous here. I wanted to thank you first for volunteering to improve the city's transparency. Your task force is a critical part of the city's liberal democratic functioning. As you will see in the coming months, many of the city's agencies do not regularly comply with the justification and notification requirements of the CPRA and Sunshine Ordinance. For example, the police department gives generic lists of justifications, if they give any at all. And the controller's office doesn't even realize that it is required under the CPRA to tell a requester whether or not responsive records existed and whether any were withheld. But your committee can help fix this. I have proposed a simple amendment to the Sunshine Ordinance requiring a notice of records requesters' rights in each of the city's responses. This boilerplate would remind requesters of their rights to appeal here or to Mr. Herrera and the right to receive notice and justification of withholding and various other rights. The vast majority of requesters are not attorneys. They are not journalists or activists who have attorneys. They do not have time to do complex legal research. So when the city fails to notify requesters of withholding, for example, they may not even realize that they do not have all of the records they are legally entitled to. And hopefully custodians sending the boilerplate are reminded of all the provisions of the law they need to follow. There is no legitimate governmental purpose in not informing the public of its rights. And because it would not change which documents are public, it should not materially cost the city anything. So I'd urge you to consider such an amendment and propose it to the Board of Supervisors if you wish. I have previously sent you a draft of this as a starting point. On a positive note, the Chief Information Officer, Ms. Jarrell, has invited me to a series of meetings with her and the Chief Information Security Officer, Mr. Maxman, and we've been collaborating over the past few weeks on the development of citywide policies and tools to release electronic records with all non-exempt metadata. I wanted to thank the Department of Technology for taking an active interest in improving the compliance of this city with its public records obligations, and I hope to have some materials to present before your December metadata hearing. Thank you very much.
Thank you. Would anyone else like to make public comment? Okay, seeing no additional public comment, let's take the next item on the agenda.
Item number 4, file number 19080, complaint filed by Paul Vanderwert against the Department of Homelessness and Supportive Housing for allegedly violating Administrative Code Section 6725 for failing to respond to an immediate disclosure request in a timely manner.
Are the petitioner and respondent here?
The petitioner is not here. He telephoned me at 2:15 today saying that he was unavailable due to a last-minute meeting, but the respondent is here.
Does the, should we ask the respondent if they, could the respondent please come up to the microphone?
Hi there.
Hi.
Hi. Abigail Stewart-Kahn with the Department of Homelessness and Supportive Housing. Thank you for having me.
Do you have a preference for either proceeding today or postponing this until all parties can be present?
I do want to make note that this is the complainant's second request for a postponement
Okay.
On this case?
on this case, yes.
Okay.
My interest is that we be as helpful to the task force as possible, and in ensuring Mr. Vanderwalt receives what he has requested from the department's perspective, and I'm happy to take you through the details if it's helpful now. We have responded with all of our responsive documents, but there still seems to be some outstanding communication around things that he has requested that we're not aware of. So if the task force can be helpful in providing guidance around that, I would be grateful. But from my perspective, we've responded as fully as we are able to at this time.
Committee members, yes.
Just to our administrator, did the petitioner request a continuance?
Yes, he did.
Did he request a continuance the last time too?
Yes, he did. He had actually requested the continuance be for today. And then today at 2:15, he said, I can't make it. And I informed him that this was his second request and that it was up to the committee on whether to go forward or not.
Did he specifically, last time, did he specifically request that the continuance be for this date?
Yes, he did.
Oh, he did, okay.
Or today?
For today, he asked that the continuance be for today.
Oh, before today, and then he called in and said he wasn't going to
And then
make.
he called at 2:15 and said, I can't make it today.
But he already requested a continuance.
He had already requested this day specifically. I
For
have it
today.
in my
Got it.
notes in my computer.
Okay. So our policy on that is a complainant may waive the 45-day rule and request a continuance. If the request is received 5 business days in advance, which it has, with a scheduled hearing, it should be granted. For requests submitted less than 5 business days in advance, or for requests for subsequent continuances, the request may be granted by simple majority of the members present. It's the only aspect with regards to, it's not yet, with regards to the complainant. So, since it should have been granted
Yeah.
by caveat of our policy.
Our policies, okay. So we will not go forward today. You want me to schedule it for
It would be scheduled in the future, and
December.
we apologize for
Yes,
you
thank you for
having to come
coming
down.
today. We appreciate it.
Absolutely, and I
thank you for being
appreciate that Ms.
amenable.
Ledger reached out to me. If there is any information from Mr. Vanderwalt about what he continues to think is outstanding, we would be grateful to receive that because, as I said, from our perspective, we've responded fully.
We will. Thank you.
Thank you.
Okay, so let's take the next item then.
Item number 5, file number 19103, complaint filed by Anonymous against Mayor London Breed, Hank Heckel, and the mayor's offices for allegedly violating Administrative Code Sections 6721, 25, and 26 by failing to respond to an immediate disclosure request in a timely and/or complete manner. Are both parties available? Mr. Heckel and Anonymous?
I'm here. Yes, I'm here on the phone.
Okay, great, thank you.
Okay, so first we're doing the anonymous first, and this is for the determination of jurisdiction.
All right, may I begin?
Yes, you may.
All right, hello, Anonymous here with case 19103 versus the Office of the Mayor. We can begin on page 16 of the PDF, which is page 62 of the record. This is a single legal issue in this complaint. I don't believe there's any factual dispute of what has happened. The question is, to what degree are written records of the future scheduling information exempt or unexempt under the Sunshine Ordinance? On October 4th, I made an immediate disclosure request for the future calendar or scheduling information from October 21st to the 28th and a few non-immediate disclosure requests. I want to correct something here. This complaint is solely about that first immediate disclosure request, so we're just going to ignore 2 and 3 here. That future calendar was fully withheld by the Office of the Mayor under Government Code 6254F, which is Security Procedures of a Police Agency, and a, quote, rule of reason analysis with no further citation to law or case. I've immediately filed this complaint and a supervisor of records complaint as well. In a few days, they provided me a press calendar for October, but they did not provide the Outlook entries. And I believe that's because the press calendar wasn't actually created by the time I had made the original request. The supervisor of records then denied this petition on the additional basis of a Supreme Court case called Times Mirror Company, which will be on the next page. Now, I'm including this request here because you can see the full breadth of it. It's not like, oh, I just want the mayor's calendar. I always have this legalese because otherwise the city can find loopholes in what I'm requesting. But you can turn to the next page. The question is the mayor's future meeting information exempt under Government Code 6254F? I do not believe it is. The clause they are using is security procedures of various offices or any state or local police agency. Of course, the mayor is not the Attorney General, the Department of Justice, the OES, or a police agency. However, the SFPD, which provides her security, is a police agency, and they can legitimately redact or remove the entries regarding her security detail. Times Mirror versus Superior Court is inapplicable in the city of San Francisco because it relies on the public interest balancing exemption or Government Code 6255. As you probably know, SF Administrative Code 67.24 G and I prohibit the use of Government Code 6255, the balancing test exemption in general, and all similar exemptions. I'm not going to go into the detail of all the argument because I know that's what the full task force is for. I would, however, like you to turn to page 48 of the PDF, which is page 94 of your record. This is a prior order of this task force, order number 18075 versus the district attorney, wherein you held that the district attorney unlawfully withheld the entirety of his future calendar. This is a different complainant here. And what you stated, and I'm going to quote from page 50 of the PDF, which is page 96 of the record, quote, the SOTF opined that future schedule/calendars are public records and should be provided in a redacted format. That's exactly what I would like the mayor's office to do. They can redact the security procedures. They can redact that stuff. What they can't redact is the politics and policies and who the lobbyists are and what staff are doing. That information is not a security procedure of the SFPD and must be disclosed. Thank you very much.
Thank you. And is the respondent ready?
Yes, I'm here. Can you hear me?
Yes, please go ahead.
Hi. Good afternoon, honorable members of the task force. This is Hank Heckel. I'm a compliance officer in the office of the mayor here to respond to Anonymous's complaint. I apologize that I had to participate by phone tonight. I was out of the office for health issues. But anyway, the background of this isn't in dispute. As Anonymous said, on October 4th, we received an immediate disclosure request for the mayor's calendar from October 21 to the 28th, so that at that time, all of those records were future prospective events and meetings that had not yet taken place. We timely responded the next business day and provided a response explaining that it was not our practice to provide future information concerning future meetings and the calendar of the mayor, and we justified that withholding and notified Anonymous of the basis under the security procedures exemption of the Public Records Act provision 6254F. Anonymous cited to that. We also pointed out specifically that that provision, in combination with the rule of reason analysis, justifies withholding such meetings because to disclose the details in advance would jeopardize the safety and security of those meetings. So we also explained that, far from withholding historical information or very recent information regarding the mayor's calendar, all of her appointments and meetings are, of course, recorded as appropriately under the Prop G provision with all the necessary information that requires. And we've provided Prop G backward-looking calendars for Anonymous several times. And we also referred him to the mayor's press calendar because there are certain events that are obviously public, press conferences, other sort of public-facing events that are announced in advance. And those are regularly provided actually on the mayor's office website. So the crux of the issue as far as the security procedures exemption is that the mayor, as some may know, receives a security detail at all times, essentially from a unit of the San Francisco Police Department. That's called the Special Investigation Detail. And so all of her internal and external meetings and events are basically staffed by members of the SFPD. So all of the details of the future calendars that are requested by Anonymous include information like the location, specific time and attendees for a meeting. And this information forms the basis for the local police department to implement procedures and make appropriate staffing decisions and postings, and basically plan the detail that will be present both for external events and also for internal events for all the meetings the mayor has at City Hall. There is an SFPD detail present. So the schedule necessarily reflects oftentimes the input of the police department in terms of the planning of those meetings. The police will consult the details of those meetings to formulate their security plans. Clearly, if someone wanted to disrupt those meetings or cause harm to the mayor, disclosing this information in advance could certainly put the mayor and the attendees to those meetings in jeopardy, as well as members of the PD. Some of us, will remember in living memory. I mean, there was an assassination of a mayor and a supervisor in that very office where the mayor currently holds her meetings. So there's some, these are extreme cases, but this is a well-worn security exemption that's been discussed by the California Supreme Court with respect to the governor's calendar. That's the Times Mirror case that's been cited in our response. It was also the basis for the supervisor of records petition denying the request that Anonymous had made. And so the city attorney through the supervisor of records has agreed with our position, and it's consistent with the Times Mirror case.
Okay, thank you. I believe we have a question from Committee Member Wolf.
This is a question to the respondent. Mr. Heckel, how are you today?
I'm fine, thank you.
Good. You invoked the rule of reason. For what reason do you invoke this?
Well, we weren't invoking the rule of reason under the sort of balancing the interest type of test. That was more of just a general statement of the security procedures exemption when sort of taken in a reasonable context, read together with the Times Mirror decision, because the Times Mirror decision did rely in part on, the public interest sort of balancing analysis. But as the supervisor of records said in its response to the petition, there's a pretty similar basis in the security procedures exemption that, it would essentially remove the efficacy of that exemption in terms of the security details being able to plan things confidentially to sort of safeguard their procedures. If you reveal all the details that the security procedures are based on, then you're essentially undermining the security procedures.
Okay, so the that's not a correct usage of the rule of reason. Rule of reason is a specific action that can be invoked with regards to the disruption of time or the excessive use of time to perform an activity. For instance, if somebody had requested emails from January 1st, 2019 to today, and all emails, there would probably be, tens of thousands, if not hundreds of thousands of emails. And if they were wanting a specific topic to be, extracted from that, that could be, the rule of reason could be invoked for that purpose. But the rule of reason, just for the purposes of, well, it kind of like stands to reason, is a completely different use of the statement. So I would just be cautious about using that term, quote unquote, rule of reason. It's specified in the California, the League of California Cities document titled A Guide to the California Public Records Act of April 2017. It's a very good document. It does explain a lot of different things. Some things the task force may not agree with, but I think it talks a lot about a lot of aspects with regards to this. I have also another question for you, Mr. Heckel.
Yeah, your point. Thank you, Chair Wolf. I do understand the distinction. I appreciate you pointing that out on the rule of reason, mechanism in terms of structuring time. And if that, we didn't intend that to be misleading.
Okay.
I think we were using it more generally as like kind of a rule of reason type of analysis, as just a general kind of term of art and as a legal term of art. So,
right.
Yeah, but I can see how that can be confusing, so I appreciate the distinction.
Okay. Also, so in my next sentence, you invoked a couple of points with regard, and this, I'm just trying to get an idea of this so that it can be transmitted to the task force. The purpose of this particular hearing is just to find jurisdiction, to collect any information that may seem unclear, make sure we have all the documents and all the records and information to help streamline the meeting, the task force main hearing. So you mentioned pretty explicitly with a pretty significant period of time with regards to meetings of the mayor or meetings with the mayor. And while I understand maybe using the example of what happened to Mayor Moscone and Supervisor Milk, I think that's I understand that, but you have to also understand who the perpetrator was in that case too. That wasn't a member of the general public. That was another member of the Board of Supervisors who does have access.
Right.
So it's not a very good example to use. I would really refrain from using that. It can be considered somewhat inflammatory. But be it as it may, the Sunshine Ordinance does allow for the public to observe certain meetings between public officials and specific parties. And I don't have that particular provision in front of me, but it is available to Sunshine Ordinance. For instance, if a supervisor were to, or even the mayor were to have a meeting specific to a specific subject, and it was set for going forward for legislation, that meeting could be open to the public to observe, not to participate, but to observe. And it's under certain circumstances. And we'll make sure that that provision is available. Moving forward.
Are you referring to passive meeting bodies or something else?
No, there's something else in the ordinance. It's not passive meeting bodies, but
Okay.
that may be contained in there too. I just we've adjudicated that before, so I just want to make both parties aware of that.
Okay.
That's all I have for the moment.
Thank you. Thank you.
I have a question for Mr. Heckel. Was there and correct me if I'm wrong, but you did not release any of the calendar. Was there a discussion about redacting what you perceived to be sensitive aspects of it and releasing the rest of the information, or why was the whole thing withheld?
I mean, all of them were future meetings at the time of the request. So, I mean, he's just requesting the calendar entries. I mean, it's all the sort of, who, what, where, when of the meeting, which is, our argument is that all of that impacts the security procedures that are sort of inextricably linked with those meetings. So, I mean, I'm not sure what Anonymous would accept. I don't know what else is left to disclose after that. I mean, if he wanted, topics that were going to be discussed or something without any reference to dates or times or places, I mean, maybe that's something that could be disclosed, but it seems he wanted the calendar. So in terms of when he says calendar, we're really viewing it as the time and place.
Do we have additional questions?
Yeah, I do. This is a question for Anonymous. I'm looking on our page 62. This is your chronology. It says on October 4th you issued the IDR, and then on October 7th it was fully withheld. Did you receive a timely response by the end of the following business day? The responding claims.
I don't remember. I think there was a weekend there, so I think they timely responded. I'm not complaining about the timeliness anyway. I want to keep this focused just on this GC 6254 issue.
Okay.
So I'm not complaining about the timeliness, even if it was an issue.
Okay.
It was a weekend, so it was a Friday or Monday.
That's okay. I mean, generally the weekends are generally skipped because it's not during business hours. It's the following business day. And I just had to ask because it was an IDR. That's just part of that. Okay, I have no further questions.
Okay. So since this is a determination of jurisdiction, do we still get, do they get to respond? No, to rebuttal. Yes, so let's take the rebuttal from the respondent first.
Mr. Heckel, you ready?
Oh, yeah. Thank you. Just to reiterate, I think this, the issue is pretty. It's a pretty narrow issue. It's pretty simple in terms of, the question is whether these future meetings necessarily implicate security sensitive information that is within the purview of 6254F and is properly withheld. And I think if you look at the Times Mirror case that we cited, we could provide a copy for the record for the full task force if that's helpful. That was dealing with the governor's request for the governor's calendar. The California Supreme Court upheld withholding those records, and there was some reference to how the calendar details for future events tend to show things like patterns and certain types of meetings taking place at certain times and places, and how someone intending to do harm to the governor in that case could get that information, and therefore it was properly withheld. And the supervisor of records in this case has stated pretty clearly in his response to Anonymous's petition that Times Mirror should be applicable, and whether it's under a balancing public interest test, which we don't use under the Sunshine Ordinance, or the 6254F security procedures exemption, which is still a valid exemption, you still get to the same outcome, that there's just too much linked up with security sensitive information in terms of how the local police department plan for and provide and implement security for the mayor for those future meetings. and to provide that in advance. Yeah, and not to give extreme examples of kind of historical tragedies, but we're not casting aspersions on anonymous motives or anything like that. But just as a general principle, there are safety considerations that we believe warrant withholding those future meetings. And we think that the public disclosure is ultimately satisfied when, you request a meeting for next Monday. You're not going to get it, but, the next day, the following Tuesday, you could request the information under Prop G, and you would, of course, get that information from the mayor's office. Thank you.
Thank you. We'll take rebuttal from the petitioner.
Thank you very much. So I want to point out, first of all, that Mr. Heckel is a lawyer. He's a very good lawyer. He doesn't act in the role of an attorney for the mayor, but his analysis works of the way a lawyer would, which is, let's look at the words of Government Code 6254F, which they are a permissive CPRA exemption for, quote, records of complaints to or investigations conducted by or records of intelligence information or security procedures of the Office of the Attorney General and the DOJ, the Office of Emergency Services, and any state or local police agency. There are further clauses, but they are relying on the first clause. The question is the title of a meeting that the mayor has with a lobbyist or with a member of the board or with her own staff a, quote, record of ... security procedure of the SFPD? I think it's pretty obvious it's not. Now, he suggested this possible compromise of maybe they can just provide the topics without the locations. I think it could be said that the locations could be a security procedure. So if they want to give me those individual calendar items, redact out the location of the meetings, and give me just the title and the description, which describes what they're discussing, that I think is at the heart of the CPRA. What are the politics and the policies that the mayor is going to be discussing? What are the lobbyists she's meeting? So if they were to just redact the location information, I think that would actually be a way to satisfy their requirements. I just want to see if you have anything else to say. Times Mayor versus Superior Court, I will also bring in, and I'll add in a copy of that case. That case does explicitly rely on the public interest balancing exemption in order to make its conclusion. And so I do not think you can actually apply that case to the city of San Francisco. Thank you very much.
Thank you. Yes.
So I'm going to make a motion, but I want to preface it by saying thank you for both of the parties. I think we hear your arguments very well. We don't claim the task force at this point in this committee doesn't claim them to make any opinion or determination about them. They are part of the record, and you're free to repeat them and bring them forward to the task force for consideration. It's not to say whether the task force will agree or disagree with any of them at that point, but good arguments nonetheless. I move that that we have all the records, this case is within the jurisdiction of the Sunshine Ordinance and the CPRA, and that and we've satisfied the 45-day rule. And forwarded to the task force.
Second.
Are we supposed to? I take those as two separate
No,
votes?
those are
okay,
it's all
all
one.
as one. So we have a motion. Do we have a second?
Second.
Do we have any public comment on the motion?
Hi, I'm Michael Petrellis, public advocate, and I want to support the anonymous person, the petitioner who's made this complaint. I have been dealing with London Breed since she was on the Fire Commission been dealing with her since she was on the Fire Commission regarding public records requests, and she is a foe F-O-E. She is a clear-cut foe of Sunshine, and I have emails from when she was on the Fire Commission basically telling me to take a hike when I wanted public records from her as a fire commissioner. I have filed numerous complaints with this body about lack of access to her calendar as a supervisor and as the mayor. And I am asking you to vote in favor of the petitioner, Anonymous. And I have to echo what Bruce said. It was very offensive to hear Mr. Henkel, on behalf of the mayor, bringing up the horrible assassinations actually that took place, I believe, 41 years ago tomorrow, to cite those assassinations as reason why today a person cannot get the mayor's calendar. I understand the future calendar. That is just part of what I see as London Breed doing everything to avoid adhering to sunshine laws. And I really wish that your full task force and these committees were airing on TV so that the public, the general public, could hear how the mayor's office today used the assassinations of George Moscone and Harvey Milk to try and deny the public access to public records. That's not okay. Thank you.
Thank you. Is there any other public comment? Seeing none? Yes, you have a
I
question.
just have, would like to also make a directive to our legal counsel with regards to Times Mirror Company versus Superior Court and Rogers versus Superior Court. With regards to this matter. Since I'm adding Rogers because it's a similar type of case, but since Times was being used by the respondent as a defense, I'd like to be some analysis in the memorandum to the task force or an addendum. Since that case, both those cases happened more than a decade prior to Prop 59, and despite them being in the book, I think it'd be good for the task force to know whether Prop 59 overruled those cases. And even though it's notated that there was no appeal to at least the Times Mirror Company versus Superior Court, Prop 59 may have, done away with the need for that.
Okay, so let's add that in as an addendum to the motion?
No,
No,
it's just
a
a direct.
request.
We're just
Okay.
it's additional information. I think that the task force, as the committee, I think we need to add in there.
Okay, so
Me to include. when is
It's
that
already
under-
part of the Times Mirror Company versus Superior Court is the one of the defense points that the respondent is using. It occurred more than 10 years of the passage of the constitutional amendment, Prop 59, which was approved unanimously by both houses of the legislature to put on the ballot. So my question to legal counsel for additional advice to the task force is whether Prop 59, as approved by the voters and essentially the complete legislature, overrules the previous court cases. I don't know because there are various specifics, and I'm not sure the specifics of Prop 59 actually did that or not. But I think that's going to, if that is going to be used, I think that needs to be part of our the legal analysis that our legal counsel provides the task force.
I'll speak with the DCAs
Yeah.
about it.
I just don't want, just for the purposes of streamlining,
Yes.
you know, if that question came up and we didn't know, then we would have to continue it in order to wait for legal counsel. So
Yeah.
in
So
order,
all right, so what I will do is direct him to this part of the tape.
right,
and then
direct
we
them
can
to this.
listen to it.
Exactly, and have it prepared for when the hearing is agendized or scheduled. Thank you.
Okay. Ready for the motion?
No, it's
Call
not
the
a
roll.
motion, it's just, it's my directive as chair.
Right, but
I
going
understand.
back to the motion.
Oh,
Yes.
yes.
Okay,
Did we
yeah.
get public comment?
Yes, we
Yes.
did.
Did you call?
Mr.
Okay.
Trellis.
Yeah.
Yes.
Yes,
So let's call the vote.
okay. Member Wolf?
Aye.
Member Wolf, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion to send to the task force passes. Okay, read the next item.
Yes, please. Thank you.
Just wrap the gavel so we
Oh.
know that's over. Thank you.
Item number 6, file number 19108, complaint filed by Anonymous against City Attorney Dennis Herrera, Elizabeth Coolbrith, and the Office Coolbrith, and Office of the City Attorney for allegedly violating Administrative Code Sections 6725, 27, 29-5 by failing to respond to an immediate disclosure request in a timely and/or complete manner, failing to respond to a public records request in a timely manner and/or complete manner, and failing to justify withholding of records, and failing to maintain a Prop G calendar. Anonymous, are you still with us?
Yes, ma'am.
Okay. Do we have a respondent? Somebody from the city attorney's office?
Anyone from the city attorney's office?
And Shirley, you had received some.
Yeah, I spoke with Elizabeth Coolbrith, and she said that Mr. Cote, who usually attends these hearings on behalf of the city attorney, was on a family vacation that had been planned months in advance. I told her that, you know, we have to have somebody present, and she said possibly Manu Pradham, who's the supervisor over there for the public records request.
And he was not able to attend, or he's not here.
I haven't heard otherwise, and if he's not here, then he's not going to attend. She said it was a good chance that nobody would be available to attend.
Okay, so if I may?
Yes.
So with regards to the respondent, so was there any correspondence as to whether they were submitting a request? Did they request the continuance?
Yes, he did. John Cote, while he was on vacation, did request a continuance.
And when was that?
And that was, what's today, Tuesday? That was last Friday.
5 business days, so that's not quite 5 business days.
It's not, no.
Okay. So our policy is if for continuances, if a respondent submits a request for continuance at least 5 business days in advance upon agreement of the complainant, the continuance shall be granted. If the complainant does not agree to the continuance, the request for continuance is not made. Wait a second. If the complainant does not agree to the continuance, or the request for the continuance is not made within 5 business days, or the respondent is requesting a subsequent continuance, such continuance shall be granted by a simple majority of the members present.
Okay, so this is the first request?
This is the first request from the respondent.
Yeah,
in
but
this
it's a
particular
request
case.
not made within 5 business days.
And at the time, Anonymous said he did not agree to the continuance. He wanted to
Right,
go
but it's
forward.
not up to the complainant.
He was just informed.
Okay, that's fine. So it's up to us whether we want to continue it.
Okay.
The city attorney just made it clear that they didn't have somebody who was knowledgeable that they could send to the hearing. That's what Elizabeth said, Ms. Coolbrith.
Hold on a second. Just want to review something here.
Do we usually give the petitioner a chance to?
You can if you want, but the decision is with the committee members.
Okay.
Because it was not prior to 5 days.
Right. So I'm reviewing my notes and they're my mental notes in with regards to reading the response from John Cote. His response to this case is quite extensive. I don't know how much more would be added with regards to his any testimony. I think if there was something outstanding that the city attorney would have sent somebody down to appear. So I would move to reject the request for continuance.
And to hear the
and
case.
to hear the case, and so it can be scheduled.
Sure.
Okay.
So that's a motion.
That's a motion. I'll, do I have a second?
I'll second, yeah.
Okay. Public comment on the motion to proceed with this today.
Hi, Michael Petrellis again. This is another indication of how the city attorney, this is the city attorney, correct? We're talking Dennis Herrera's office? Yeah, okay. I just want to make sure I'm not confusing it with the district attorney, the former district attorney. Dennis Herrera is no friend of Sunshine, and this absence on the part of his office, which is just riddled with lawyers and spokespeople and experts, the fact that they can't send anyone to this body today when they are based in this building is really offensive to democracy. And I want to applaud the petitioner for the documents he's requested and for pursuing this complaint before this committee.
Thank you. Is there any additional public comment?
This is Hank Heckel again. Could I make a comment, not on behalf of the city attorney's office?
Yes, please go ahead.
Yeah, I don't have any knowledge of why there's no one in attendance there. Would the committee be amenable to? I could sort of check in with their office and see if they want to send somebody up there to respond. I mean, I can't say that would be successful, but if they want to make an appearance, it could have just been an oversight or something.
Can I just respond to that? Mr. Heckel, I appreciate that, but we're in the middle of a hearing, and they were well aware when this hearing was scheduled. There were two responses from the city attorney's office, one that Mr. Cote wouldn't be able to make it, and then one from Mr. Cote that he was requesting a continuance not within the time frame. If there was really I don't know, it's just a little unusual that we would suspend or recess our meeting to put a call upstairs or downstairs actually, or is it this floor? I'm not sure what floor it's on, second floor, to do that. I hear you, but I think it's a little unusual request to make to disrupt the flow of our meeting for such a thing. It's one thing if we've had situations where the police during our hearings, regular task force hearings, the police commission is having their hearing at the same time and trying to get a respondent to come back and forth to those hearings. That's something that we might, table something for a little while till they finish whatever's going on. That's something different. But I hope you follow what my gist.
No, I follow you. I mean, I wasn't suggesting necessarily that you suspend the meeting, but I mean, I could ping somebody if, to the extent the meeting continues, or if there's other matters to take up, and someone could get there before the meeting just kind of naturally comes to a close. But that's up to the committee.
Excuse me, am I allowed to comment on this motion since I haven't been heard yet?
No, this is public comment. It's
public comment on the procedural.
I see.
It's on a procedural motion.
So is he allowed?
You know, it's unusual.
Yeah, it is.
You know, I think if the chair wants to allow it, I'm okay.
I mean, he hasn't been heard as to what.
Yeah, actually,
maybe
we
he
haven't
wants.
heard today. We heard through Cheryl what you had previously said. Yes, if you'd like to make a public comment on your feelings about either proceeding today or postponing, we'd like to hear from you.
Sure. Thank you very much. So I believe we should continue for a few reasons. I agree with the Chair Wolf on the fact that they've given quite a detailed legal analysis in their response. This is not a complaint that's fairly new where things are still moving around. It's another one of those very specific legal issues. And moreover, I understand Mr. Cote can't make it. He has a vacation. But as one of the commenters said, there are 300 employees of the city attorney's office and 150 licensed attorneys. They have a 67.21E obligation to send someone, even if telephonically, to the case. So I would urge you, please let me continue my hearing and have my 45 days. Thank you very much.
Okay, I just want to clarify to Anonymous, you're asking that the case be scheduled, not to be continued, correct?
I am asking you to, maybe I'm not using the right word, I'm asking you to let me have my hearing today, however you prefer.
Okay.
You would like us to proceed today, not to continue the matter, which would mean we would do it on a different day.
Correct. I would like you to proceed today. Sorry for the confusion.
Okay.
Sure.
All right,
Thank you.
we'll go ahead.
Okay. So,
So we had,
Call the roll.
let's call the roll on this.
Member Wolf?
aye.
Member Wolf, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion continue, the matter passes. I mean, to hear the matter passes. Apologize.
Okay. So let's hear from the petitioner.
Thank you very much. May I begin?
Yes.
All right. So Anonymous here again for case 19108, Anonymous versus the Office of the City Attorney et al. We're going to begin on page 6 of your PDF, which is page 148 of the record. The heart of this case is I am alleging that the City Attorney's Office does not even maintain a Proposition G calendar in accordance with the law. On October 8th, I made an IDR for a future calendar, which we're not going to discuss today, so I'm trying to keep these issues separate, and a past calendar for September 30th through October 7th, calendars of Herrera. You can see the legalese on the second slide here, but it's both Prop G and non-Prop G calendars. Of course, on October 8th, only some of those days were 3 business days past the date of the calendar. However, for those days, they must be able to provide a Prop G calendar at the very least. They also have to provide non-Prop G calendars. At the very least, they got to provide the Prop G calendar. The timeline here, I don't think it is at issue. The only issue with the timeline here is I do not believe the respondent actually responded to the task force, to Ms. Leger, in a timely manner in accordance with your complaint procedure. They're supposed to respond within 5 business days or 1 week. They took many, many weeks to respond, if I remember correctly. And if you go to the next page, you will see the 6729-5 allegation here, which is that the law requires that, quote, the city attorney shall keep or cause to be kept a daily calendar wherein is recorded the time and place of each meeting or event attended by that official, et cetera, for meetings not otherwise publicly recorded, the calendar shall include a general statement of issues discussed, and you can see the 3 business days subsequent to the calendar entry date issue. Now, this is just an excerpt. The full calendar they disclosed is in the remainder of the record. As you can see, these events have a general statement, but they do not have the place. And because these aren't actually on the half an hour or on the hour, I asked for the actual, individual records. We've discussed this before. Not the ICS, not the metadata, just individual printouts of each and every one of those events so I can get the exact time. They haven't done that. And this calendar does not include the location, which is a violation of the law. If you look at the next slide here, that's just various other issues related to this complaint. They did not provide the justifications for why they had withheld certain information until after we filed a complaint. I confirmed with the city attorney's office before I filed a complaint, do you consider this response complete? Do you have any other records to give me? They said yes, and I filed a complaint. That's not allowed. They can't just give you the justifications or give the justifications after a complaint is filed. They have to give those with the response. And I'm also alleging that there are non-property calendars because I don't think that the city attorney can exist with just this level of detail for scheduling. If you remember in case 19047 versus the Office of the Mayor, during the committee hearing, Mr. Heckel told you, well, there's no other substantive information other than what they'd given me in the property calendar. That turned out to be not true. Unfortunately, there's no way for me to figure out this information, to really know whether they have a non-property calendar. I have to allege it. Hopefully they will, honestly come up with that or provide full justification for why they would withhold the entirety of any other non-property calendars they have. I don't really have a lot more to go here, although you can flip to page 162 of the record, which is page 20 of the PDF. Here you can see the actual PDF they give me of the calendar. None of these events have locations, even events that are outside of the city hall. And you can't really tell what time they are because they're not on the hour and a half now. So yeah, I think that the city attorney just doesn't keep a fully legitimate Prop G calendar, and they need to do so. That's the most important part of this complaint. Thank you very much.
Thank you. Since we don't have the respondent here, we can take your rebuttal.
I don't think it is
Or
much
maybe
for
that's
a
it.
but.
So do we have committee members? What are our thoughts on this?
Yeah, I think we have all the information that's needed. Reading through the petitioner's complaint and reading the respondent's response to them, I think we have enough information.
I would agree. There's the respondent's letter is detailed enough to know what they would say here.
Right. So I would move this to the task force to find in jurisdiction. I find that the information is public and that the 45-day rule has been satisfied.
Second.
Okay. Any public comment on this motion? I'm seeing none in the room. Is there any public comment from the phone? Hearing none, let's call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Motion to move to the full task force passes.
Thank you, everyone. Let's call the next item.
Item number 7, file number 1911, complaint filed by Michael Petrellis against Supervisor Rafael Mandelman for allegedly violating Administrative Code Section 6721 by failing to respond to a request for public records in a timely and/or complete manner.
So I see we have the petitioner here. Do we have someone for the respondent? Okay. Let's begin with the petitioner's statement.
Yes, I just have to pull up an email that I'm sorry I don't believe I sent you, but I can certainly share with you on my cell phone. Hi, my name is Michael Petrellis, and I filed an immediate disclosure request in early October for emails, texts, and calendar entries for Supervisor Mandelman. This was an immediate disclosure request, and the office asked for extra time to look for records. They also asked that I be more specific in terms of emails to look for, and I gave them, I believe, about 10 or a dozen subjects to search for. As of today, I have received emails that were sent or received by Mandelman's email address, and I've also received close to 500 pages regarding other documents. What I have not received are the texts that Mandelman has sent and received. And I want to look at page P258 in the guide here. This is the letter from Tom Temprano, the Chief of Staff. He lays out in a 3-page letter, why they don't think that that there's legitimacy to my complaint. And I am very troubled by the second to last paragraph where Mr. Temprano alleges that my request is expansive and burdensome. You know, that's democracy. That's sunshine. It is an expansive request that I made, and to dismiss the sunshine law that I am using, to dismiss my concerns and what I am asking for as expansive and burdensome, shows me that the supervisor's office is really not a friend of sunshine. Tom ends his letter by saying, "My complaint is without merit, and we request that the task force determine that our office has not committed any violation." Well, it was an immediate disclosure request filed, I believe, on October 7. Today is November 26, and I don't have the texts. What I received on Wednesday, November 20th, from the Mandelman staff at sfgov.org handle was, they said, in response to my wanting clarification about when they provided me with emails and the things, it says that those records were provided to me on November 19th. I believe that November 19th is way past the deadline. They should have provided me with those documents because it was an IDR. They say that per our previous conversation, your request for text messages is voluminous in nature and raises a number of technical challenges regarding searching for and producing records. I have been down this road before with other public officials where they say the responsive documents are voluminous. It's a vague word. How do they define voluminous? 10 pages, 100 pages, 1,000 pages? I asked that in my response to the Mandelman staff, and I've not received any response. And they're again saying it raises a number of technical challenges. What are these technical challenges? I think they are looking for excuses not to adhere to the Sunshine Law and get me the documents requested in the time outlined by the Sunshine Law.
Thank you. We'd like to hear from the respondent next.
Thank you, task force members. My name is Tom Temprano. I'm the Chief of Staff for Supervisor Mandelman. As noted in the formal response provided to the task force, our office has worked diligently and in good faith to comply with the public records request made by Mr. Petrellis on October 7th. We have been in regular communication with Mr. Petrellis, sending him 7 emails releasing records and updating him on the progress of his request. And to date, we have provided him with 880 pages of calendars and emails on a rolling basis as he has requested. As we stated to Mr. Petrellis in our initial communication, his request is voluminous, expansive, and burdensome. His request seeks thousands of pages of calendar entries, emails, and text messages. Each of these documents requires individual review by staff for any applicable redactions or withholdings. Accommodating this request to this point has required many hours of staff time from our office, as well as the Office of the Clerk of the Board of Supervisors and the City Attorney. To date, our office has spent over 30 hours of staff time processing his request, and I must say we believe strongly, and the supervisor believes strongly in the importance of the Sunshine Ordinance and the work that this task force does. However, we have had to balance his requests with the dozens of daily requests that we receive from constituents and our duties staffing working the supervisor as a member of the Board of Supervisors and on the various committees and boards on which he serves. Throughout Supervisor Mandelman's 16 months in office, we have complied with many sunshine requests and have never received a complaint. The request by Mr. Petrellis was certainly the largest and most expansive we have received. Despite the expansive nature of this request, as I noted, we have already provided 880 pages of documents to Mr. Petrellis. I could detail the communications we've had, but I've provided those emails in your packet. We have, as Mr. Petrellis, I guess in brief, we did respond to his immediate disclosure requests, noting that due to the voluminous nature of the materials requested, we would be unable to provide the responsive records immediately, but would continue to respond further. On October 9th, Mr. Petrellis did request that the release of responsive records occur on a rolling basis, which we certainly have accommodated. On October 15th, as Mr. Petrellis noted, we did ask for him to refine the search term for emails. The supervisor's email receives hundreds of emails each day, and we appreciate his working with us to narrow the search terms. On October 23rd, we provided Mr. Petrellis with all calendar entries from January to March. This was a 100-page document. On October 30th, we provided further entries from April to June. These records totaled 155 pages. On October 31st, and again on November 12th, we did receive response from Mr. Petrellis noting that he had received these calendar entries. On November 12th, we provided the final calendar entries requested by Mr. Petrellis, which totaled 134 pages. Finally, on November 19th, we provided Mr. Petrellis with all emails sent or received from September 1st through October 7th that included his provided search terms. These records totaled 491 pages of documents that were submitted to Mr. Petrellis. We do, as he noted, have one outstanding item that he has requested, and we will continue to work diligently with Mr. Petrellis as we have over the last 6 weeks to complete the remainder of his request in a way that allows us to provide the records he seeks in good faith. I do believe that Mr. Petrellis' allegations of violations to the Sunshine Ordinance are without merit. Our office has complied with his request and done so in consultation with the Records and Project Manager of the Board of Supervisors and the City Attorney's Office to ensure that no violations were committed. We have continued to provide Mr. Petrellis with documents on a rolling basis, which was his request, and we have done so regularly and in a timely fashion. I know that the clerk of this task force asked Mr. Petrellis whether, in light of the significant number of documents already provided, he would like to continue with his complaint. He has chosen to do so, which is certainly his right, but I do believe that the significant documentation that we have provided the task force as well as Mr. Petrellis, the good faith we've displayed, and our intent to fully finish and comply with his request makes this complaint without merit, and we would ask that the task force determine that our office has not committed any violation and dismiss the complaint.
Thank you. Okay, we have a question, and then I have a question.
So I just want to preface it by saying this is not the meeting where we'll make a determination. This is just the meeting to find jurisdiction, make sure we have all the records, and to satisfy the 45-day rule to find that the records are public. Mr. Petrellis, I have a question, and if it's something other than what I think it is, I'll ask the respondent for confirmation. When you filed the IDR, did you receive a response by the end of the following business day?
Yes.
Okay, thank you. That's all the information, questions I have.
I have a question for the respondent. Can you give us a couple of details about what the challenges are in terms of providing the text messages?
Sure, absolutely. Thank you. So the technical challenges, and again, we are working. We are not a staff of public records experts nor attorneys, so we have been working closely. So forgive my reading with the record staff at the Board of Supervisors. But the technical challenges that exist, and we have, we will comply with this request. the technical challenge is that these text messages exist on Supervisor Mandelman's personal cell phone, and their extraction is going to require him personally, because it is his personal cell phone, to parse through every communication with every individual on his personal device for the time period in question, which, if you have an iPhone, will also require him going through every communication in his phone in order to determine whether there was a communication during that time period. He then has to identify any potentially responsive communications and extract them, whether by screenshotting, by actually dictating to a staff member, and then having staff go through and make sure that we have done any required redactions of that information. The request for text messages is a period of about 37 days, and similar to emails, the supervisor receives dozens, if not hundreds, of text messages per day that he now needs to personally parse through in order to accommodate this request. He will do that. We will do that as staff. It just requires a level of technical expertise that we are grappling with and trying to work with the clerk of the board to determine if there's any easier way. But unfortunately, the best they had was him sitting there and going through every single text and determining what is in fact responsive and how we can then provide those records.
I have a question for Mr. Porcello.
Yes, please.
I'm just curious. Have you requested text messages before
Yes, I have.
from anyone else? And have you had trouble getting them?
With the former district attorney, George Gascon, there was too long a period he took, in my opinion, to provide me with the texts, and I believe I filed a complaint with this body regarding that, and that a determination was made that the first of all, the city attorney, the district attorney, had to give me the text, and he should have given me the text within the short time period required from an immediate disclosure request. Off the top of my head, I cannot think of another public official to whom I have requested their texts.
Okay. Thank you.
Okay. Do we have any other questions or thoughts on this?
No.
Okay. So let's proceed with rebuttals from the respondent first.
Thank you again, committee members. I do feel that in my statement I laid out a compelling argument for the good faith that our office has exhibited in working with Mr. Petrellis to accommodate what is a very large request, and also outlined our willingness to complete that request with Mr. Petrellis. Thank you for your consideration of this item.
Thank you. Let's reset the clock, and we'll take the rebuttal from the petitioner.
Hi, Michael Petrellis again. Okay, the clerk of the board has certainly heard from me and other members of the public regarding requests for a lot of records. And it seems that City Hall still doesn't have their act together in terms of figuring out a way to review things such as texts. Cell phones were not invented yesterday. I believe all of these supervisors, the city attorney, and the clerk of the board have not diligently developed policies to help the public officials respond to such requests. They keep coming here and saying the responsive records that we have found are voluminous, and they never spell out what is voluminous. They said the emails were voluminous. They gave me just under 500 pages. In my definition, that's not voluminous, okay? The technical problems they're talking about, we're in the middle of Tech America. These people in City Hall can't go to Tech America and say, help us figure out how to better respond to public records requests. I'm calling BS again on this public official's office, as I have with the other public officials to whom I have made similar requests. I also have to point out the supervisor has so much free time on his hand. He is also an elected member of the Democratic County Central Committee. When you look at his social media, you see that he is holding fundraising parties for his other elected office. He and his staff have plenty of time to deal with my requests and other sunshine requests, and I believe that when the supervisor has 3 paid staff, they've got the time to respond to my request in less than 2 months. I am just not accepting the argument that Mr. Temprano is making that it's so burdensome. The supervisor is not showing his commitment to sunshine. And a final point I want to make, and I harp about this for years now, I don't hear the supervisor saying he's going to find the $45,000 necessary to air the Sunshine Ordinance Task Force meetings on SF.gov TV. That, to me, would show a real commitment to the sunshine work.
Thank you.
I'm
yes.
ready. So I make a motion to recommend this to the Sunshine Ordinance Task Force. We find the documents to be public and that's within the jurisdiction of the task force, and that we satisfy the 45-day rule.
Do we have a second?
Second.
Is there any public comment on this motion?
Yes, on the phone.
Okay. We'll take your public comment. Hang on 1 second for the clock. Okay, please go ahead.
All right, this is Anonymous again. As always, this is directed solely at the task force and is not in any way legal advice to the complainant. While the complainant has addressed various allegations of the Sunshine Ordinance being violated in this case, you have sua sponte jurisdiction under SF Administrative Code 67.30 to find any person violating the Sunshine Ordinance. And I believe there are numerous more violations in this record than just those that have been alleged. First, about the technical complexity of providing text records. You may remember that I will actually be proceeding against the mayor for a very similar issue, which is that they use personal accounts to store these text messages or Instagram or whatever it is, or WhatsApp. That's case 19091. And it could be a violation of Administrative Code 67.29-7 for a failure to maintain all correspondence in a professional manner in a way that can be disclosed. There may also be violations of 67295 because the calendars may not meet the Proposition G calendar. They've actually redacted things from their Prop G calendars, it looks. It also appears there may be a violation of SF Admin Code 67.26, which requires clear reference for every single redaction and withholding to a statutory or case law justification. If you look, for example, at page 325 of the record, which is page 103 of the PDF, there are numerous redactions in this calendar, and I don't know why some of these could be. For example, why would the name of the staff member who made a calendar invite be stored in this record? Why should it be redacted? Good faith is not actually relevant to whether or not a violation of most parts of the administrative code have been upheld. And I believe the California courts have said that as well. It's the Public Records Act that allows us to verify officials act in good faith. We don't have to assume that. So I would ask that you find at this level that jurisdiction and records are public in favor of the complainant. Thank you.
Thank you. Is there any other public comment, either in the room or on the phone?
Yeah, I'd like to make a comment. This is Hank Heckel from the
Okay,
Mayor's
hang on 1
office
second.
again.
We're going to reset the clock.
Yep.
Okay, go ahead.
Yeah, I'd just like to kind of zero in on a very specific point with respect to the text message production. I can speak from experience. It's extremely difficult, both practically and technologically, to fulfill wide-ranging requests that seek text requests, which are disclosable under the Public Records Act and the Sunshine Ordinance, and there's case law on this in the San Jose versus Superior Court decision, which makes it clear that it's the responsibility of the owners of personal accounts and personal devices, to the extent they're used for city business, to do that search themselves. But as we know from experience, if you tried to do this on an iPhone, for example, there's really no way to do a keyword search or a date-specific search. So when you're dealing with searches that are kind of all over the map and sort of for a long period of time without, reference to specific correspondence with specific individuals, it can be very challenging. And I don't think anonymous, I think, was referring to curtailing the ability of officials to use personal devices. We in the city, there's no, for the most part, we're not issued government phones. So public officials would be very limited in their ability to communicate if they were not able to use personal phones in keeping with some requirement to maintain records in a business-like fashion. So to the extent they are used, it does present challenges in responding to these requests. And I'm not really certain what the solutions are for that, but there may be some technical fixes or tools that are used probably in the litigation context, might provide some basis, some insight into how to deal with these types of requests. But I do want to make the point that it is very challenging to provide text messages on a large scale. Thanks.
Thank you. Is there any other public comment? Seeing no public comment, let's call the roll.
Member Wolf?
Aye.
Member Wolf, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Motion to forward to the task force passes.
Thank you, everyone. Sorry? Yes, item number 8.
Final item, item number 8, file number 19114, complaint filed by Shane Andrews against Tyler Vu and the Public Defender's Office for allegedly violating Administrative Code Section 6724, 25, 26, 27, and 29 by failing to respond to an immediate disclosure request in a timely and/or complete manner.
Do we have both the petitioner and respondent here? Okay. Let's hear from the petitioner first.
Okay.
Hang on one second. We're waiting for the clock. Go ahead.
Okay. Good evening, everyone. Thank you for your time. So our office sent a public records request to the Public Defender's Office requesting 18 specific categories of documents. 66 days later, we received responses to only 5 of those, and we received only 6 highly redacted emails. Based just on that, it certainly was untimely. That sort of response certainly could have been given in 10 days. More importantly, the remaining 13 items, there was no specific response. It did a catch-all response that, somewhat contradictorily too, that they were either not public records or they're public records. However, they're privileged, either because they're attorney work product or attorney-client privileged communications. You can imagine, given the nature of the entity we're asking records from, right, the Public Defender's Office, that could cover everything. And so the Sunshine Ordinance requires, at the very least, you explain if it's a public record, based on what? If it's privileged, how so? And even if it is privileged or public, do your best to disclose something. We received none of those. So I went as far as in the complaint to put out, well, here's why, in fact, the ordinance says they are public. Emails, records about public allegations of misconduct against public officials, that even if the records involved actual litigations, that once the litigations are complete, you then disclose the information. We petitioned the city attorney's office saying, could you take a look at this? The city attorney said, well, some of them might be privileged, but the fact remains, we don't know, right? So maybe, but so we proceeded with the complaint, and I was hopeful that in response, the Public Defender's Office, because it was specifically asked, tell us what you did, where you looked to try and find responsive documents. Instead, the response was, we don't get many of these requests, we don't have a process in place, and then it regurgitated everything they had already provided, which was essentially nothing. So that's why we're here, probably most importantly, just to get a response as to why we didn't receive anything, and if they're making these claims, on what grounds. That's all. Thank you.
Thank you. Let's hear from the respondent next.
Members of the board, my name is Tyler Vu, and I am the information manager
Thank you. We need the clock. There we go. Okay.
Members of the board, my name is Tyler Vu, and I'm the information manager for the Public Defender's Office. With regards to the nature of the work that our office does, the court in the case of Coronado Police Officers Association versus Carroll has sort of put the Public Defender's Office, even though it is a public agency, noted that it has a very private function in a sense that it represents private individuals. And what the court tried to do was compare our clients to a client of a private law firm, and sort of said that our clients were entitled to sort of the same effective advocacy as a private law firm would be entitled to for private clients. And that some of the function that we have, although it is public in nature, deals with specific private individuals. And in that particular case, what the court said was that data collected by the public defender about police officers, who public defenders routinely deal with on a daily basis, even though it is a public agency, fulfills the public defender's private function, and therefore is not coverable by the Sunshine Ordinance. And that's exactly what we told petitioner, was that the items requested from the petitioner were items alleging misconduct by district attorneys and public defenders, and those items did not exist outside of in the public realm. Those items, to the extent that they arose in a courtroom setting in the course of representing someone, a private individual. And what the court looked at in Coronado was essentially the same thing, which was that items collected by the Public Defender's Office was collected in the course of representing private people for use for private clients later. So when petitioner says that we were relying upon the same, we didn't provide an explanation, just relying upon a prior explanation, the reason is because the Coronado case is on point and directly addresses the issues before this current task force now, which is that the records collected by the Public Defender's Office, although it is from a public agency, concerns private clients and concerns a private function of the Public Defender's Office and therefore not disclosable. We did make every effort to fulfill the requests. With regards to items of calendar entries, we did search for calendar entries, and we did notify a petitioner that we did not have any records, public or private, relating to the calendar entries. With regards to the first two items regarding articles, we did search for those articles, and we did tell petitioner that there were records that fulfilled the public nature, and we did disclose those records to petitioner as well. And then petitioner had also requested items from different jurisdictions, of which we do not have any records for, and we did let petitioner know that in fact we did not have any records for. But mainly, I think petitioner is not happy with the case law as it applies to public defenders' offices, and wants to this board to look around that.
Thank you. We have a question, yes.
Mr. Vu? So this is a bit extensive. It's really going to apply more for at the task force level to ferret out some of these details. But just for the sake of asking, the case law that you had laid out, and with regard, so have both parties been in court about this issue before?
No, this is actually, and I think no,
Okay.
we have not. And in fact, this request is first of all, it's the first time we've ever had a request of this nature,
Okay.
and that sort of explains our initial delay in our first two correspondence with petitioner. But
Okay, go ahead, finish.
and since then, every single item of correspondence has been an update. We provided them with documentation on an average of almost once every 10 days since then. So it was a new situation for my office.
And the case law that you cited that applies to the public defender, does that have any connection with the petitioner?
Yes, it does.
It directly?
Well,
in name?
In that, I'm sorry.
I mean, in name?
No, it does not.
Okay.
It is arguing by precedent,
Okay.
by example, by analogy.
Okay, very good. Thank you. That's all the questions I have.
I guess I have questions for and I'm actually not sure whether, I think for the petitioner. So you're asking for documents related to employee conduct that happen to have happened within the course of work on specific cases?
No, it isn't. None of the requests have anything to do with specific cases, nor any of their specific clients. So that's part of the confusion about the objection. The Coronado case is just a case law for the general proposition that public agencies like the Public Defender's Office, or the District Attorney's Office for that matter, in a lot of ways have the same concerns that private practices do with respect to attorney-client communications. Great, fine. But if you're to read Coronado the way the Public Defender's Office is trying to read it, then we'd never have to produce any documents ever, because they would say, by virtue of the fact that it exists in our office, it's somehow connected to a case or a client or a future case or client. And so the argument's even more tenuous here because, well, first of all, this records request was in response to their formal complaint against Mr. Ostley, a district attorney. Their office has made numerous public records requests to the district attorney's office for the same information. So which is it? Is it, you can ask for it on the one hand, but you won't give it on the other? It's contradictory. It runs afoul of the whole purpose of the ordinance. And lastly, the specific requests are about only public officials. It's about requests about allegations of misconduct, public record, says in the ordinance, about one by one, specific public officials, all either public defenders or district attorneys. It could not be more plain, more simple, more clear. And the fact that it took 66 days to get 6 emails, not a single text message. And in fact, even of the 6 emails, they really have to do with neither of those requests. So they're even less significant. But the point being, all you have to do is look at the requests and the response, or lack of response, frankly, and it's a clear violation. It's untimely, there's no response, no explanation. And so if that is considered a response, forget good faith. If that's sufficient, then the Public Defender's Office will never have to produce records in response to a sunshine ordinance request.
Thank you. Do we have any other questions up here?
No.
Okay. Let's go to rebuttals. We'll hear from the respondent first.
I do want to correct an earlier statement saying that our office has used the public records request against the DA's office. That has never happened. That's factually not correct. Petitioner also said that if our reading of the law were correct, then we would never have to release anything. That's also factually not correct, because we did release items that we thought were public in nature. The other thing too is that the petitioner has said that we are public actors, and in fact, the work that we do is we do not have any complaints. We do not have complaints outside of the work of representing individual clients. The only time complaints actually come up are in the course of representing individual clients. So there are no records for us to produce because they simply do not exist. We do not have any records of district attorneys jaywalking as a complaint. We do not have any records of district attorneys stealing or being dishonest outside of their work of prosecuting our clients. Just like we do not have any public records of complaints against our employees for doing things outside of their representing the clients. So unfortunately, the records that petitioner is looking for simply do not exist in the course of the work that we do. To the extent that we had meetings about public issues or articles, those items were turned over to petitioner, which kind of goes against the argument that we never have to provide records. We do, and we did. It's just not what he wants because it doesn't exist. Thank you.
Thank you. We'll have the rebuttal now from the petitioner.
Unfortunately, I'm afraid I'm going to leave here more confused because, again, well, as far as public records requests for documents to the DA's office, whether it was a public records request or a subpoena, the bottom line is they requested records, Mr. Ostley's cell phone text messages. So that was the point. Doesn't matter what you want to call it. In practice, what's good for the goose is good for the gander, or should be in any event. Again, not forgetting too that, so I think I just heard respondents say, we do respond, and we did in this case. But at the same time, the response was, we never get these responses. So I'm not sure how you can say, of course we respond. Or at least maybe we would. We don't know because we never get these. But here we are. Let's use this one. They haven't responded. They have not produced anything in the realm of reason. And let's just hone it all into one thing. Okay? Their public officials filed a formal complaint against another public official from the district attorney's office. We requested any communications in their office about Mr. Ostley. Neither a client, not having to do with any particular case, in response to an action that their office initiated, and yet somehow they don't have anything. And that is simply not believable. And I heard the respondent up here say, well, we can't respond because we don't have anything to produce. Well, that's not what their response said. If that were true, that's all they should have done. And maybe I wouldn't even be here. We don't have any responsive documents. But that's not what they said. They said, your requests aren't public in nature. I showed why they are. They said your requests violate the attorney-client privilege. I say, no, they don't, and you haven't shown me why or given me any good faith reason to believe that's true. So there's, in every violation of the ordinance we allege, there is more than substantial evidence, information to prove the violation. And still, more than 66 days later, and an opportunity to come here and explain why the delay or why there's not a more clear answer, it's just more contradictions and still no response. So, thank you.
Thank you. Committee members, do we have any questions or thoughts? Do we have a motion?
I'll make motion. Is that okay for you?
Yeah.
Okay. I'll move to finding jurisdiction, find that the records are public, and that the 45-day rule has been satisfied, and to forward it to the Sunshine Ordinance Task Force.
Second.
Okay. Do we have any public comment on this motion, either in person or on the phone? I see someone in person. And
Hi,
wait
Michael
for the clock. Thank you.
Hi, Michael Petrellis again. I'm in favor of this motion, and I believe this is the first time I'm aware of a complaint against the Public Defender's Office. And I'm really curious to see how the full task force is going to delve into this issue and what they're going to decide. I have looked upon the Public Defender's Office, especially under the late Jeff Fadaci and the current fellow who's in charge, whose name I can't remember, as progressives. And it's quite surprising to be listening to this complaint and the response from the PD's office about a public records request, and the petitioner's not happy. And thinking, wait a minute, isn't this the progressive San Francisco PD's office? It's another matter that I believe should be put forth before the public on SFGov TV. I no longer believe that just the full task force meetings need to be aired. These committee meetings where a lot of the details come out need to be aired so that we see the machinations of our city government when dealing with sunshine issues. And I want to conclude, and I can say this now because you're not considering my matter, but I thank all of the members for your volunteer time because you are really helping democracy.
Thank you. Do we have any additional public comment from parties not involved in the matter?
May I speak?
Yes, please. Hang on. Wait for the clock. Go ahead.
So once again, anonymous here, this is directed solely at the task force and is not in any way legal advice to the complainant. I find this case one of the most fascinating cases because it appears to be a proxy fight between the district attorney and the public defender's office, both of which are public agencies. But I guess there's a private law firm doing the actual public records quest. So I can't wait to see what happens at the full task force. But I would like to draw your attention to two things. First of all, which is on page 472 of the record, you will see that the respondent states that because they receive relatively few requests for public records, they, quote, until now did not have a structured system in place to timely respond to such requests, end quote. And there is no excuse for this. The Administrative Code, the Sunshine Ordinance, and CPRA have been there for decades. This is a law, and public officials have to follow the law. It doesn't matter how often they receive these requests. Second, there may be violations that have not been alleged, but that you can find in your sua sponte jurisdiction under Administrative Code 67.30, violations of 67.26 and 67.27, wherein every single redaction needs to be justified. At my first glance, it didn't appear that was happening. Two other issues of note. This requester has asked for the original electronic records with all the metadata, and so I'm actually really looking forward to how that part of the complaint goes forward. Maybe the city responds differently when you have expensive lawyers making the request rather than when it's a random person and they don't really care. And now on the last point, though, I do think that the Public Defender's Office attorney-client privilege should be very well protected. It is very important that private citizens be protected using the Public Defender's Office, and they have all of the protections that they would have if they paid for their own attorneys. So that's going to be very interesting, and I do think this task force should uphold the attorney-client privilege for the Public Defender's Office as strongly as possible. Thank you very much.
Thank you. Is there any additional public comment? Seeing none, shall we call the vote?
Member Wolf?
Aye.
Member Wolf, aye. Member Hensy?
Aye.
Member Hensy, aye. Chair LaHood?
Aye.
Chair LaHood, aye. The motion is sent to the full task force passes.
Thank you. Next item, please.
Item number 9, adjournment.
Yes, before we do that.
Yeah, usually we would put a line in there for committees so the committee members can have, announcements or,
Okay.
additional
Okay.
Can we do that now?
comments. Well, I'm just going to take if you'll allow it, I'm just going to take the liberty.
I will allow it.
Okay, great. And we'll take public comment on it, too. I wanted to, and I'm going to bring this up at the task force meeting, too, listening and reviewing some of the committees. I think it's it's good to start here, but when committees are listening to complaints, it would be helpful, and it sometimes can trigger committee members to want to start adjudicating case because of the way both parties are presenting the case. And I think it would be worthwhile for the committees to inform the parties, but also prior to that to have something in the complaint process to advise the public and the respondents that their testimony for the purposes of this particular venue, to find jurisdiction, to find whether the documents are public, and to satisfy the 45-day rule, that the arguments should be pertinent to those points.
Yeah.
If
You're right.
Yeah, I agree.
If a party feels that for some reason it's not within the jurisdiction, that should be the thrust of their testimony.
I agree.
Because everything else is already part of the record and actually really pertains to what the task force needs to hear.
In the next, yes.
When it's scheduled for adjudication or for determination. The merits of the case are really not applicable here, except for whether we feel some clarification is made because, a point is vague, or if there was a defense without a citation, to inquire about that. So because that's part of the scope of points that the task force will have to take into account. So really, we're kind of, the first shot at this is our administrator to make sure that all the records are collected for this part, and then it's up to us to make sure that listening to the parties, whether did they submit enough. And actually, I did have a question for our administrator about the last case. I didn't notice in their the respondents' submission of documents, an actual response from the public defender's office.
Letter of some sort?
Was it in there? I didn't see one.
I don't recall off the top of my head, but
Okay, can you just double check? Because I just find that to be a little unusual, because that's, pretty specific to our process. And I see a lot of correspondence between the two parties, but I don't see one to the task force. So,
Wait, you mean on page 472?
Like a response letter.
470 what?
It's 472.
Oh, wait, it's all the way down to
Yeah.
the bottom. Okay.
It's addressed to the Sunshine Ordinance Task Force.
Okay. So I missed that. Wait a second. 472?
I try to put things in chronological
Oh, there
order.
it is. Oh, okay. I think these documents, this particular document, like we have the original complaint at the top, that, and then we have for the petitioner is generally their letter to, requesting.
They addressed it
Right. I think for the respondent, we should have the latest, at least their response to be first. If the rest of the documents are in, ascending order, that's fine, but the task force should know that you're doing it that way, or just put everything in descending order because
So
this
reverse
response would,
chronological?
yeah. Well, it could be chronological. Well, I don't know. I mean, that's the other thing is, it's hard. You don't want to have the administrator have to do the task of breaking
Right.
things down chronologically. It could
Yeah.
be chronological upon receipt.
Right.
I think that's what you're talking about, right? But I think at least it should be in descending order, so that way the response is first.
Okay.
And that way the oldest, at the bottom, it's like reading
Is
an
in the
email,
back.
the latest,
Yeah, exactly.
the most recent message is at the top, and then you have the history going all the way descending down. I just think it'd make it a little more easier for us to follow,
And to find the most recent material.
Right, because I was
Yeah.
gonna, I didn't write it down. I was kind of slipped my mind. I was going to ask the respondent about that, but thanks for pointing that out, because I'm seeing like page after page of the seal of the public defender, and I didn't quite pick it up in that way. Also,
Yeah.
I'll make a note to be more careful.
yeah, no, it's not that. It's just the way your style is, and that's okay. I'm just thinking that
Yeah.
it'd
It's
just
a
be
reference.
easier for us
Yeah.
all to, because it's a lot of pages for us to go through. If the first one is the response, and we can read the response, and they have references to everything below it, then we can just scan for whatever particular items that are specific in the response.
A lot of times I'll get a response letter and supporting documents. So I try to print them out all at once and clip them together.
Okay.
That way, when I go to organize the materials, at least I see what it was.
Right.
And
That makes sense.
Exhibit A isn't mistaken for Exhibit E or something.
Right, I get it.
So,
But the response letter is outside of the exhibits, so it's really kind of the,
well, if there
cover
are
letter.
exhibits to the response letter, I try to clip it all together. That's what I'm
I
talking about.
see,
Yeah.
I see, okay. All right,
Does that happen?
yeah,
That makes sense.
Yeah.
okay, that's it.
Okay. Any other committee
Yeah,
discussion?
I agree with you on providing some clarity in the complaint procedures and to the public at at the sort of beginning of every committee meeting. I forget, does rules handle updates to complaint procedures, or does the complaint committee do
Well,
that?
generally, the complaint committee will review
Okay.
the complaint process
Yeah.
and can make recommendations on the complaint process itself.
Okay.
Or if it seems like it'll cross over into rules, but it's either way. If
Yeah,
I would
I
take the
just was-
recommendation from the complaint committee.
Yeah.
And then
Okay.
just implement
I
whatever
just-
they recommend when we're having these
Right,
hearings.
but then everybody else has to know, because
I
we're.
just
we
was
have-
checking to make sure if it was mine or not.
It's,
for
if
rules.
you, if you as chair of rules feels that it should come through rules, then
No, it should probably be a complaint thing, but
okay.
I just wanted to see.
It's your prerogative to
Yeah.
ask for that.
Yeah. Okay.
Okay.
Actually, I had a question. Did you want me to include the same preamble that we do before task force hearings now
Yes,
in all our agendas?
yes,
All right, I'll do that from now on.
yes. And you can print it right on the agenda.
Oh, that's a good
That's
idea.
what I did
Yeah.
for
Okay.
the December hearing.
Right.
Yeah.
Yeah, make it easier. Okay.
Yeah.
Okay.
All right.
Did I miss anything
Public
else?
No.
Any public comment on our discussions here?
I have can I speak?
Please, yes.
All right. So I understand what the chair is saying. All that I'd ask is, if it is the case that that's all that these hearings have to establish, I think I would hope that maybe you can change your complaint procedure such that if both the respondent and the complainant is okay submitting, say, quote, on the briefs, we wouldn't have to come to two hearings, because it's very rare that someone disputes jurisdiction. So I would ask that you consider, if that's all you want to discuss here, that if your DCA says that, hey, they don't dispute jurisdiction, and the letter doesn't dispute jurisdiction, and it's very clear to you what's in these written records, that I would ask that you allow both the respondent and the complainant to only appear at the merits hearing, and to consider that for you. Thank you.
We have a response to that.
So I just want to respond to the public comment from Anonymous. Having been on this task force on and off since 2005, this is something that we've had to wrangle with many times, and actually the complaint process has been amended several times with regards to that. The reason why it has ended up the way it is because many times when one or the other or both parties do not show up for the complaint procedure, that when we get to the task force, it's found that there are lots of information or records that should have been part of the case that aren't. And it's up to the complaint procedure in the process of this particular hearing to make sure that all those, the record is as complete as possible. And the only way to do that without wasting the time at the task force hearings is to spend the time here to investigate that. The whole process of discovery is done in the public venue, and it's the bulk of it, as far as making sure all the information is part of the record and is complete, starts here in this preliminary part of the process, and then the rest of it is happening at the task force level. It's my job as the chair of the task force to assure that enough time is given and we can squeeze as many cases as possible into an evening, be it that we are volunteers, we only meet once a month, but at the same time be able to make sure that at this level that we can ascertain that the file is complete. So that's why we ask for that, because even if both parties don't object that it might not be in jurisdiction or what have you, the job isn't just for jurisdiction. It's also to make sure that the record is complete, and that if there are any clarifying questions that need to be asked, that be noted for the briefing from the committee to the task force before the hearing begins. I hope that answers your question.
Yes, thank you.
Okay, any other public comment? Seeing none, let's call the last item.
Item number 9, adjournment.
Move to adjourn.
Second.
Let's take it by acclamation. Thank you, everyone.
All right.
It is 6:30.
Thank you.
Good job.
Hi, everyone. Thank you.